monthly compliance and regulatory webinar series to all of our members as well as our non-members. We'll discuss the latest in news regarding the complicated and constantly changing regulatory environment that affect all of us in the contact center industry. After today, we'll have one webinar left for 2018, and we'll be discussing call labeling and blocking. So please check the PACE website for more details regarding that. As we prepare to start the webinar for today, we wanted to remind you of a couple of housekeeping items. All of your participant lines are on mute right now. If you'd like to ask a question, please do so in the chat box on the right-hand side of your screen, and we will get to as many questions as possible during the last 10 to 15 minutes of our time today. This webinar is being recorded, and the recording of the webinar will be available on the PACE website in just a few days. If you would like to receive the slides from today's webinar, please send me an email at chris.herrick@paceassociation.org, and I'll be happy to send them to you. Without further ado, I'd like to introduce the panelists for today's webinar. Lisa Mesner. As a litigation director at MacMurray & Shuster, Lisa focuses her practice on the unique needs of businesses facing complex civil lawsuits. She has successfully defended businesses in highly regulated industries against class actions and government enforcement actions across the country. Lisa litigates in a variety of jurisdictions and has been successfully admitted into the pro-hack vice basis to federal district courts, including Illinois, Texas, and California, where she has defended a variety of complex lawsuits as well as agency enforcement actions related to consumer protection laws and regulations. Bringing more than 17 years of litigation experience, Lisa utilizes a litigation process that focuses on the unique business model, culture, and goals of her client to craft a defense strategy specifically targeted to meet that client's goals. In addition to her litigation practice, she also assists clients with achieving industry and statutory compliance, conducting employee training, and proactively improving internal policies and procedures to minimize future litigation risks. Michelle Shuster. Michelle is a founding partner of MacMurray & Shuster, where she brings extensive experience in working with clients of all sizes involved in highly regulated industries. She has established a solid record of representing clients in consumer protection matters before state attorneys general, the FTC, and FCC, in addition to conducting regulatory compliance audits and providing counsel on advertising and privacy issues. Michelle currently serves as general counsel to PACE, the Professional Association for Customer Engagement, and oversees its self-regulatory organization program. In this role, and with her significant depth of experience related to TCPA compliance, she has been an integral part of PACE's current challenge to the FCC's TCPA order. She has an exceptional foundation in U.S. privacy laws and regulations and is accredited as both a certified information privacy professional through the International Association of Privacy Professionals and Customer Engagement Compliance Professional through PACE. And with that, I will now turn over the floor to Michelle and Lisa.
Chris, thank you for that very wonderful, flattering, and lengthy introduction. We appreciate it. So thank you all for joining us for our presentation on employment issues today. Lisa and I have noticed an increase in enforcement actions and more relevant probably to our discussion today, litigation around employment issues in call centers. So I thought as one of our monthly compliance webinars, it would be a good idea to explore some of the issues associated primarily with the Fair Labor Standards Act and contact centers and what plaintiffs' attorneys have been up to lately. I just want to give a quick reminder that it's important to obtain independent and your own legal advice when you are facing issues, especially in the employment area. The presentation that we're giving today is meant to provide general guidance, but specific legal counsel is always something that we would recommend. And then with that, Lisa, I'd like to turn it over for you to get started on our employment issues.
Yeah, thank you, Michelle, and thank you, Chris, for the lovely introduction. And so we started the substance of our slide with one of my favorite quotes that I usually bring out when we're talking about litigation and trends in litigation. And it's an old Voltaire quote: "I was never ruined but twice, once when I lost a lawsuit and once when I won one." And so it seems somewhat ironic to be in that situation to talk about that, but the topic we're going to talk about today fits squarely within that quote, because losing a lawsuit related to these types of employment issues can be completely catastrophic and devastating. We know a couple of the most recent jury verdicts and settlements to result from FLSA type of actions against big companies, namely FedEx and Walmart, exceeded $200 million in liability. And so obviously losing a lawsuit in this context is catastrophic. On the other hand, winning one is not any kind of walk in the park. If you have to fully litigate a case, in the current landscape, to fully litigate a case that raises these types of employment issues, for even a small type of company, legal fees can easily exceed 6 figures. And so it's kind of a catch-22, and we hope by the information that we're going to share with you today that everybody can take away a little bit more knowledge to make sure that they are better prepared to combat this kind of situation. And so why are we talking about litigation? Because I think that, first of all, if you can be familiar with the landscape and the universe of the laws that apply and some of the very common pitfalls, it can help you reduce the fear of the unknown and what's out there. It can help you come into compliance and to minimize any risks of future litigation. And then I think that if we talk about litigation and what can happen if a worst case scenario occurs and there is a lawsuit or a threatened lawsuit or a regulatory enforcement action, if you can understand the process and the options, then I think that you'll just have a better understanding. You'll be able to communicate with your counsel in a more clear fashion, and you will have an overall understanding of what the best course of action is going forward to meet the specific needs and goals of your business and what you want to accomplish should that happen. And so with that being said, what Michelle and I have been seeing is first and foremost coming out of particularly large call centers and similar types of employment places is the failure to classify employees correctly. And so I just have a few bullet points here, and then I want to explain how those relate, I think, to call centers specifically. So first, titling an employee as a manager or with some kind of specific nomenclature that people typically think as an employee who would be exempt from overtime pay laws does not make them exempt under the law. The title itself really is very meaningless. The actual duties of the employee is what will determine whether or not they're considered an exempt status. And so one that comes to mind and that I think we've seen at least a few times is folks who operate dialer systems. So they have different kinds of titles, but their functions are very similar in that they're operating fairly sophisticated machinery. But in many instances, the type of actual work that they're doing is not complicated enough to justify a high-level exemption such as a computer specialist exemption, because they're really not necessarily actually doing the coding of the dialer. They're maybe just putting in load files. And so we have received some indication from the Department of Labor that that in and of itself is not going to be sufficient to avail them of any kind of computer specialist type of exemption because they're not actually doing the coding. They're just simply loading files. The other instance that we have seen is where companies label these types of dialer programmers as some type of management level employee, such as dialer manager or dialer operator manager. And that is also not sufficient legally to establish that they are a management level employee, because under the law, 80% or more of their job duties have to actually involve supervising and having certain kinds of hire and fire authority that that person may not actually do. And so, you know, with that, Michelle, I don't know if you have anything to add in terms of anything that you're seeing or any experiences you've heard directly from your clients.
Yeah, so I think it goes without saying, but I'm going to say it anyway, is that, you know, when we're talking about exempt classifications of employees, we're obviously talking about being exempt from overtime under the Fair Labor Standards Act and also state regulations. So this type of classification is a really important consideration as you are hiring individuals for call centers and determining whether they'll be overtime eligible or overtime exempt. And this is the area where we are seeing a number of challenges, especially from plaintiffs' attorneys, that what they do is they find an employee that, I will tell you frequently, it starts with a disgruntled employee who is either terminated or not happy with their current position, and they meet with a plaintiff's attorney who specializes in these types of employment issues. And one of the first things that that attorney will explore is, were you classified correctly as an employee if you were not offered overtime in your position? And that is the, you know, the type of legal analysis that we're talking about here. And if you do have these individuals who have been, that you have labeled as exempt from overtime, and it turns out that they were improperly classified, then there is a burden regarding establishing how much overtime there is, and frequently the employers are tasked with that. So, you know, this is an important issue that Lisa is talking about here, and as we look at how those fines can be calculated, you can see that it very quickly becomes an expensive proposition if it is not done properly at the time an employee is onboarded.
And I would add to that, Michelle, that the other thing that we sometimes see is a lack of very high-level description of what these particular employees, what their jobs entail, or a somewhat misleading description, such as indicating that there are some management duties that are in fact not. And in a recent matter, there was actually some email evidence used against the company to indicate that there was a lack of managerial authority. And so those are things that just in terms of a compliance tip that are good to take a look at in terms of how are we defining what the employee does on paper, and are those realistic, are they true, and then by the sheer definition of a job duty, is that something that's going to fit with an exemption under the Fair Labor Standards Act. And even if you don't have enough employees to trigger the federal law, which is going to be 50, there still, it could be a tandem state law that might apply to you. So we'd be remiss if we didn't at least mention that you should look at both angles when you're taking a look at how you want to classify employees. And then more importantly is to take a look at, for those employees that you don't seek to classify as exempt, but they are in fact hourly employees, which are, you know, the customer service, we're thinking of the customer service representatives are going to be typically hourly paid employees, is how are we computing overtime if we're asking these employees to work in hours in excess of 40 in a week. And so there's several considerations here, and the biggest one that I think that we're seeing trending in call centers is incentive compensation. And I think that everybody agrees that incentive compensation is good for everyone involved. It's good for the company because it provides an incentive for employees to hit certain objectives that help keep companies profitable. It is good for the employees because it gives them an extra ability to be able to, earn more money for good results and accomplishing good results, whether that's sales or volume quota, whatever the case may be. When hourly paid employees do work hours over 40 in a week, they are required to be paid 1 1/2 times their hourly rate. Where the pitfall occurs is that if they are paid a base rate of, say, $12 an hour, and then in addition to that, they're eligible to earn incentive pay, that incentive pay must be calculated in terms of deciding what their effective hourly rate is of pay for overtime. And it's very difficult for companies to keep up with it because the incentive pay can vary from day to day, week to week, month to month, depending on the manner in which the incentive pay is earned. And so it's very easy to have very costly mistakes in making the computation by either excluding the incentive pay from the hourly rate altogether or not computing it in a correct manner because of maybe the manner in which that the incentives are paid is on a monthly basis. So then that makes it difficult to compute what that would be on a weekly basis. And that's a big pitfall that we're seeing right now. And so to go back to that, what we tell people to do typically, and it usually works, is to work with their payroll processor to make sure that there is a formulaic way that is being used to account for the incentives. Now, what I would caution is that we've seen some instances that even with that, payroll processors use some kind of formula that accounts for an average or something like that. And that is not always correct. It really has to be week by week because under the federal law standards, which have largely been adopted by most of the states, the week-to-week period is where the 40 hours is looked at. And you really should be looking at what your pay period is. And so if your pay period is Sunday to Saturday, that's the time period in which the 40 hours accrues. If you're on a biweekly period, you need to break that out from the start of it to 7 days and then follow the next 7 days. And so it really has to be when the incentives were earned tied back to that weekly period. And then you would compute it by taking the incentives and adding it into the normal hourly rate for the 40 hours and then just doing the math to figure out what's the effective rate for that week. And so then it can vary. And then what you find sometimes is that employees don't necessarily understand why there can be these variations in their pay and their effective hourly rate, leading to some of the point that Michelle had made earlier about employees becoming disgruntled and not understanding. And so would also encourage, call centers, particularly HR reps within call centers, to make sure employees understand there can be a variation and it is dependent upon your incentive compensation, and just so that there's less opportunity for them to become disgruntled or confused about the manner in which they're paid. And I think that the degree of transparency there is well worth it. And similar to incentive pay, a lot of companies use either gift cards or some other kind of prize or award as a contest for closing rates, or maybe there's some kind of internal contest for, can this team earn more closing volume or more dollars, sales dollars within a certain time period, and then there's gift cards awarded or other kinds of prizes that aren't actually wages. And then no one even thinks about it, but that is technically compensation that should also be included for purposes of an employee's effective hourly rate. And how you compute that is so difficult that, you know, it's almost not even worth having these types of incentives. Because unless it's a gift card that can be a finite measurable amount, it's just almost impossible to go back and make sure that a payroll processor is effectively adding that in for an hourly rate of pay. And so that is a big pitfall. And then I would also just caution that going back to this on the gift cards, it's not something that I think that employees think of in and of themselves. I think that it is when a disgruntled employee falls into the lap of a clever lawyer, they will investigate all these sources of how were you paid, was there anything excluded from an effective hourly rate one time that, you know, that may have resulted in an error. And so that, you know, that's kind of what we're seeing in terms of some of the pitfalls that are occurring. And so, you know, the problem then becomes that mistake, albeit innocent, is very costly. Under federal law, if there is a finding that there has been a violation of the Fair Labor Standards Act, which includes failure to pay overtime or failure to properly compute what that rate would be, the employer can be subject to what's called liquidated damages under the law. It's a fancy way of saying double damages. And the award of attorney's favor, or the award of attorney's fees in favor of the employee is mandatory under the law. It's not discretionary. The language of the statute reads that this employee shall be entitled to an award of attorney's fees, which courts have said is absolutely mandatory. So if this type of liability would fall on a company, they're paying for their own legal fees in defense. They're paying for the plaintiff's legal fees to prosecute, and it can be, that in and of itself can be even more costly than the underlying liability. The federal law also provides for a unique form of class action liability under this type of law. And so I know that many the companies in this organization are familiar with class actions generally that might arise under the TCPA or the Fair Debt Collection Practices Act or some other kind of consumer protection law like that. The class action liability under the federal law from the employment standpoint is a little bit different in that it's actually even more so favorable to plaintiffs, and it can shift the costs of notice onto the employer. It can alert an entire call center's employees that are present and have worked at that facility for the previous 3 years of potential liability, and it can become very, very costly, burdensome. People will join in the lawsuit just on the hope that they're going to get paid money and not necessarily have any individualized way to show that they aren't owed any money. And the evidentiary standards that the courts apply are very unfavorable to employers as well, allowing certain kinds of inferences and estimates by employees to control over the company's own records. And so when you take all those things in tandem, the type of liability and the type of legal standards that apply to companies are so overbearing that it's just a type of liability that you want to avoid at all costs if possible. And so I guess before we get to questions, I would just maybe go back over to Michelle and ask her to weigh in on anything over incentive pay that, or this gift card issue that she may have seen that may have been of interest to the audience.
You know, the one thing I would say, you know, we hire vendors and we expect them to provide us with competent services, and that's true for the payroll processors that we hire. But we have seen instances where payroll processors have not accurately calculated pay, especially in the overtime arena. And as a result, the company has underpaid an employee and then faces an Fair Labor Standards Act wage and hour claim. And the fact that the company is not the responsible party, meaning that they provided the proper guidance to the payroll processing company, that is not relevant. The fact that the payroll processing company made a mistake is still going to be a finding of liability against the company. So I think that it's very important that we audit our vendors, our payroll vendors, on a pretty regular basis to make sure that they are calculating pay correctly and that we're not leading ourselves into an area where we could have FLSA liability. And then, Lisa, I think it might be worthwhile also maybe mentioning, so we've talked about private litigation here, but the Department of Labor can get involved in these types of actions too. What have you seen with companies that it's not a private litigant, a former employee who's initiating this with a plaintiff's attorney, but rather through the Department of Labor? What does that process look like?
That process looks ugly. And understand the Department of Labor, there's a federal Department of Labor, and then each state has its own state Department of Labor. And so what we typically see is an employee becomes disgruntled about something. And it doesn't even necessarily have to be wages. It could be that, maybe they perceive that someone in management's being a little obtuse or harassing to them in some fashion. And then all over the internet, if you just Google, Department of Labor complaint, you will easily get access to a form where you can make a complaint federally and to the state. And so upon making a complaint to a Department of Labor, in my experience, some type of auditor at the Department of Labor is going to make a request of the company for at least some employee records. And in looking through maybe that particular personnel file for that particular employee who has made a complaint, they'll uncover that maybe overtime wasn't computed correctly, or maybe there was some kind of incentive pay that hadn't been added in. These kinds of things we're talking about today. Maybe they see a red flag within someone's file that had occurred. The Department of Labor, federally and in every state, has the full authority to then come in, if they see this, and audit every employee's files for the previous 3 years who have worked for the company. And I've defended these types of audits, and they can take years to go through. And the liability can be astronomical. And the attorney's fees just in going through file after file after file. And I've seen it even happen where it's hundreds of employees involved, and they're literally owed a very de minimis amount, $20 or less. And the Department of Labor will still require the company to pay that plus liquidated damages plus their cost of investigation. And I've even seen it to where the Department of Labor would order all of that to be done and still not release a company in a lawsuit type of context where you get like a release, your liability is released. They will not sign agreements that contain that release, and then the employees can turn around and try to sue the company. And so I guess I would say that if you would ever receive any type of notice from a Department of Labor, whether it be a state or federal agency, that an employee has complained, you take it seriously, and that you seek independent legal counsel in crafting a response so that you can make sure you're avoiding that kind of very catastrophic event.
Yeah, good advice. Good advice. So, Lisa, have you always been on the defense side of these employment issues?
I have not. I have not.
You know I wasn't going to let you off the phone without bringing
No. I did plaintiff side work probably for about 7 years, and so I think that how that allows me to benefit companies now is number one, I have a respect for properly paying employees. The law says they're entitled to it. We should do those things as a best business practice. But I think that it puts me in a unique position to understand the mindset of where a plaintiff's lawyer is coming from. and what the strategy is, and where they're headed with things, because that's the best way to play defense, is to know what's coming at you on the offense.
Good way, I think, to wrap up the overall presentation. We've left time at the end for questions. We have a chat box that's available in your interface to the Adobe Connect, so feel free to type questions in there.
There's a couple that we have already, and go figure that Mr. Mark Bomer has a couple already. So I'm gonna start off with a couple of his for you.
No questions for Mark Bomer. No questions for Mark Bomer. I'm Mark. I'm just teasing you.
So here's the first one that we have from Mr. Bomer. He says, in relation to the calculation of effective hourly rates, does the EHR get maintained or updated on a yearly basis, or is it calculated within the discrete pay period in which the overtime is incurred and paid?
Yeah, that's a good question. It is to be calculated within that discrete pay period in which the overtime is incurred and paid. And so that, under the law, is on a one-week basis. And that's true even if you pay your employees on a biweekly basis or a monthly basis or some other increment of time. Under the law, the effective hourly rate goes on a week-to-week basis, and it's based on that 40-hour work week. So any hours over the 40 hours is going to be deemed overtime, and then that's going to trigger that 1.5 times rate, and it will be unique to that pay period.
Here's a question that I had just as you were going through, Lisa, and because it kind of struck me. What happens if an employee complains to the Department of Labor, but they don't end up filing a lawsuit?
You mean the Department of Labor doesn't file a lawsuit, or the employee doesn't file a lawsuit?
Well, I don't know, like either way. I mean, so there's a complaint out there, but I mean, it's just sitting in limbo. Does the company get investigated, or is it just, is there a target on their back or anything like that?
Not necessarily. So you can imagine that the Department of Labor gets a lot of employee complaints, and that a lot of them probably are complaints that may or may not have merit from some kind of equitable standpoint, but not a legal one. But if there is some kind of violation of the law, the Department of Labor has a lot of regulatory power, including just a demand that it be remediated through payment or through a settlement. But they also have the authority to file a lawsuit. And the employee individually also has the ability in an individual capacity to file a private lawsuit.
Okay. Before we go back into Mark's next one, and this is coming from my background from a compliance officer standpoint, because when we had vendors, we always had to make sure they were in compliance. So if you use a payroll processor, what do you have to do to make sure that your payroll processor is computing the pay correctly? Is there an audit type document that you have to go through or something like that? How do you make sure they're in compliance, I guess?
Yeah, that is a good question. And Michelle kind of hit on that earlier, because if the payroll processor does something incorrectly, that's not going to eliminate liability from the company. And so in terms of an audit, I would recommend that companies demand to see the formula being used to compute overtime by the vendor, and to have some kind of record indicating that the formula was checked, double-checked, maybe spot-checked against a few employees that actually did hit overtime with some kind of incentive pay or something in there that needed to be computed on a weekly basis. And then the other thing, that can be done and to protect a company is to actually have agreements with vendors that are willing to put their money where their mouth is and sign contracts saying they would indemnify the employer in the event that there was some kind of error like that. And then, one other consideration is that the law, this particular law, penalizes employees who act what they call in a knowingly way, in a willful or knowing way, at a harsher rate than employers who do not. And so I would say that a vendor mistake would take them outside of that willful and knowing type of liability, to where that could negate 3 years of liability and only make it 2 years of liability, and it would negate any type of double damages, to where the employees would only be owed the actual unpaid wages. And so I would say with those three things together, those are considerations in terms of a payroll processor. And I would never hesitate as a company where I know it is, ultimately going to potentially be my liability, to require those payroll processors to do some kind of audit with some degree of frequency, whether that be monthly or quarterly, and something of those natures. And I think that that's a best practice to protect the company.
Okay, great. And then going back to Mark Bomer's second question, he said, is there any defined minimum amount of incentive compensation, gifts, etc., that does not need to be incorporated into the effective hourly rate calculation?
Right. So, and that's another good question, and that's one that Michelle and I have seen recently with call centers, because sometimes the incentive compensation does render, if you will, a change in the effective hourly rate to be de minimis. And there is an exception within the federal law that has also been applied across most state laws for what's called a de minimis exception. It's what's called, is that you owe the employee such a de minimis amount of money that it's not even worth the lawsuit. However, in my view, the case law has all but degraded that to mean nothing, because the case law even says, if somebody is requiring more than 2 minutes to do something, they should be paid for it. Things less than $20 have held outside of the de minimis, to where if it's still a $20 difference in total that the employee is owed, over a period of 2 or 3 years, it wasn't de minimis. And so I think that the best answer to that question, if we're looking at it from, a business best practice, is there's not going to be any minimum amount of incentive compensation that should not be factored in for purposes of overtime.
Okay, great. I think there's one last question that oh, sorry, Mr. Bomer's typing. So I'll ask this question and then we'll come back to his. Is there any way around paying time and a half for overtime?
There is not. I guess that if you want to completely avoid the issue, you just don't permit overtime hours to be worked. And a lot of companies have just gone to that as a matter of practice, that overtime's just strictly prohibited. It's not allowed under any circumstance. They write it into their handbooks. They write it into their company policies. They instruct their managers, if that employee's hours are 9 to 5, they don't punch in early and they don't clock out late. 9 to 5 means 9 to 5, and that they're very stringent on that. One piece of caution I would extend is that a lot of companies, and one very large auto company many years ago had a policy of requiring employees to clock in 15 minutes early, so that the employee could then clock in, walk to their station of work, and be ready to start working right when the line dropped at whatever time it commenced, say 8 in the morning, and then did not allow them to clock off until the line ceased at, say, 5 o'clock in the evening. And then it would take that employee, maybe 10 or 15 minutes to clock out for the day. And the courts have held that, that walking back and forth is being engaged to wait. It's being, it's part of the work day. And there was a finding that that was compensable time. And so that would be a word of advice. And it may not really be applicable to call centers, because I would think that for a lot of the customer service folks, when they log into their computer, that somehow captures their start of their workday, and log out probably does that. And there wouldn't be any kind of extended walking or waiting period to get to where you needed to be to start work. But that's just something to keep in mind as a company policy, to not permit clocking in and out other than during the regular hours of work.
Okay. And then this is the last question from Mark. Again, so to be clear, a $10 Starbucks gift card won during a raffle should be incorporated into the EHR.
Yes.
Okay. All right. Well, I think that's everything there. And as you can see, you have the contact information for Miss Lisa and Miss Michelle, as well as their email and the phone number to MacMurray and Shuster. I want to thank you both again for taking the time to do this webinar today. It was very insightful. And I just want to remind people of just a couple of things. We will have our last compliance webinar in our 2018 series on November 15th at 1 p.m. Eastern. It's discussing call labeling and blocking with Michelle. She'll be on again, as well as Carl Koster. We'll also be hosting our first ever Contact Center Summit in Princeton, New Jersey, and that's actually going to be on November 14th. There's a lot of discussions that we're going to have regarding compliance and contact center operations. You can find out more about this event on the PACE website, or you can also register. The other thing I'm going to ask you to check out is you can also see other things related to our benchmark portal webinars that we have, and that's around operations. And also we do have our dates picked out, and we're also taking registrations and hotel reservations for our 2019 convention and expo, and that is going to be held in San Antonio. So all that information is on the PACE website. If you have any questions, don't hesitate to reach out to me or anyone else on the PACE staff. I thank you all for your time today. Have a good rest of your week and enjoy your weekend. Thank you so much, everyone. Have a great day. Bye now.